that's...
Welcome, everyone, to the very first session of the Ethics and the Professions series that will be ongoing throughout this year, looking at different professions: law, medicine, journalism, engineering, business, maybe religion, education, as the year goes on. And thank you very much for coming. Can we get a sense of where people are coming from in terms of your backgrounds? For example, how many of you are undergraduates?
All of you?
How many of you are law students?
Oh, half and
About
half.
half and half. And how many of you are practicing attorneys or otherwise, got one there, right? Okay, good. Anybody I missed in the categories? Yes? From?
Oh, no, sorry.
Oh, okay. Good. Come on in so we can see you.
And grab some dinner. We
Yeah,
don't
now
mind
there
if you're
should be
late.
dinner. Oh, here are plates. So those of you who didn't get dinner, get a plate, get some dinner. Come on in and try to get in here close enough so we can all see each other in a circle here. I'm Scotty McLennan. I'm the Dean for Religious Life at Stanford, and I've been here for about 12 years. Previously to that, I was the university chaplain at Tufts University, and for about 17 years, I taught at the Harvard Business School on a sort of one-day-a-week basis, business ethics. Before that, I practiced law for 10 years, legal services work in a low-income neighborhood in Boston. I'm an attorney and a Unitarian Universalist minister, and did actually teach a course about a dozen years ago on ethics and the professions. And I'm really glad that we have this opportunity to do this a little bit more informally in this kind of context. And I'm particularly pleased that Professor Deborah Rhode, who has a long and very strong reputation nationally and internationally in legal ethics, as well as being a professor here at the law school, is the first person in this series, and I'll let her self-introduce herself. By the way, both of us are undergraduates from Yale, so we have that connection going way back.
Right. And I then went to Yale Law School and clerked for Thurgood Marshall and have been teaching here for about 3 decades. My areas of expertise are in legal ethics, coincidentally, and gender law and policy. I also teach leadership. I've headed the Ethics Center, which is sponsoring this. I was the founding director of that, and am the founding president of the International Association of Legal Ethics, and have written a lot about legal ethics and ethics in the profession over the years. So I'm delighted to have this opportunity. And we thought we would just talk for no more than a half an hour and then throw it open to the questions that you all have.
So for us to start off, maybe we should say something about it's ethics and the professions, but what is a profession? And what does it mean to profess something in your life and get paid for it? How does law differ as a profession from a business or a trade or something else? And what does it mean to be in a profession? You had some thoughts on that as we talked.
Well, yes, Scotty and I had a little preliminary run-through on this, and I quoted back from him a famous phrase from Roscoe Pound, the former dean of the Harvard Law School, who wrote a history of the legal profession and legal ethics, in which he said a profession is a learned art in the spirit of a public service, which I think is as good a definition as any. And it's the kind of rhetoric that gets trotted out as after-dinner speeches at bar association functions when everybody has had just enough so that they're not offended by the platitudinous sound of it. But whether there's a significant difference between business and the professions is, I think, a lively debate, and one in which some of you may wish to weigh in. There's certainly a widespread view among private practitioners today that that distinction is much overstated, and the profession should just get its act together and recognize what has always been true, that it is about making money, and should do it more effectively with the kinds of techniques that business schools have pioneered over the years, and which we do not adequately teach in the law school. And then there are those who view that as the eternal decline of the business into the profession. And you can really trace what one of my colleagues calls declension rhetoric this, for the last 150 years. And you can find bar association presidents lamenting the sorry state of the profession's decline into a business literally for well over a century. So is there a there? And to the extent that there is, I think it revolves around the public service component. And a lot of lawyers do take that seriously. That's part of what I think does distinguish us from a business, although there is certainly a strong corporate social responsibility contingency in the business world that would dispute whether we're any more public service minded than enlightened businessmen are. But I think historically, that's been one of the differences. And we've been thought to have ethical obligations to society as a whole that other professions don't share.
But and indeed, there is a code of professional responsibility, rules of professional responsibility. A lot of that's quite uniform now nationally, although California is, I don't think, quite on board nationally. But what about that? The fact that there is a code of ethics and that, unlike business, we're supposed to follow particular rules as a profession.
Well, it's a code of ethics that's been drafted by and for lawyers. So put that in proper perspective. And mainly what's required, and certainly what's largely enforced, are rules that track criminal prohibitions, with some special rules that relate to the roles, the unique roles that lawyers serve in society. So on conflicts of interest, for example, and confidentiality. The difference between having a professional code is that for egregious violations, you can have your license yanked, and occasionally lawyers do. But just to give you a sense of that, something on the order of less than 2% of public complaints about lawyers result in any public discipline, let alone disbarment. So it's really quite rare for lawyers to lose their license as a result of ethical infractions.
So maybe another part of what you're saying is, since these rules are written by lawyers for lawyers, it's a guild. It's, going back to medieval times. This is a profession which is different than a lot of business relationships in that there is a brotherhood and now a sisterhood of guild members. And doesn't that make it different from trades and businesses?
Well, again, to quote Roscoe Pound, he said, an association of lawyers is not the same as a retail grocers association. And, I think if he was right, was for the wrong reasons. Lawyers, no less than retail grocers, are interested in their own self-interest, and they draft the codes accordingly. What distinguishes lawyers is their ability to package it as public in the public interest. And also, lawyers have a lock, after all, on many of the decision-making branches of government that exercise control over other occupations. So it's ex-lawyers who are on the bench and ex-lawyers who are serving in legislatures, and in the executive branch. So we have a lot more power than other occupations. And sometimes it's exercised to good end, and I don't want to understate that. We're a profession that's been at the forefront of every progressive social movement in this country. There are a lot of public-spirited lawyers out there who do enormous work for social justice, and I'm happy to teach them. I have them in class. I'm teaching a course now on lawyers and social change, and every one of those is going to be a member of the profession who takes very seriously their obligations to the public interest. But I think, we shouldn't get overly complacent and shouldn't overstate the differences between us and those who are in business. And I certainly doubt that if you compared someone did an interesting study and compared the moral views and beliefs of lawyers and inmates of a state penitentiary system and found no actual demonstrable differences. What seemed to change their career paths were their opportunity structures, so to speak, and their peer influences. But I think that to set us up as some sort of extraordinary moral exemplars overstates the case, much as we would like it to be true.
Well, it is true that if you look at Americans' trust in various professions, Gallup does this annually, you have vying between pharmacists and physicians and dentists, interestingly, at the top, and you have lawyers way down, just above used car salesmen.
Yeah, we narrowly beat them out, but it's close.
So that's not particularly encouraging. Well, let me try something else then. What about the fact that you said this is a learned art? That is, people have to go to law school for 3 years. Business people don't have to go to business school to be successful and to have, they don't have to have a license. They don't have to be part of some association. So doesn't that make law somewhat different than business and trades and others?
Well, a lot of what lawyers do is, how to put this nicely, not rocket science. And, are we that much more learned than other occupational groups that aren't recognized as a profession? Information technology, computer programming, I think there are other groups that could rival us in terms of the technical competence that's required to adequately practice. Which is not to say that we don't have special expertise. Clearly we do, and the requirement that lawyers attend 3 years of law school and pass a bar exam is a substantial barrier to entry. It's probably not one that's needed for a lot of the routine work that lawyers do, and there's a flip side of the way we've constructed the professional monopoly, which means that a lot of people are paying a lot of money to have what's the functional equivalent of a surgeon piercing an ear. We reserve a lot of tasks to lawyers that could be just as effectively and much more cheaply performed by individuals with somewhat less training, and other countries do it better when it comes to that. And they have access to legal services for the poor and middle class that are certainly much more advanced than our own.
I must say, when I went to law school, I was amazed by the first-year law school curriculum, which is quite common across the country, so there's a uniformity to that. That was pretty interesting. But we were also told in my day that we're teaching you to think like a lawyer. And to think like a lawyer is completely different than other kinds of thought that are soft and mushy, and there are a variety of ways of talking about it. But you're learning procedure, a criminal procedure, civil procedure. You're learning how to read cases. You're learning what judges do and how they do it. You're learning how they interact with legislatures and so on. And in the process, I felt by the end of my first year, yes, this is quite different information than I'd ever had, but why didn't I get this in elementary school and in high school? And this is stuff that could have been taught as part of citizenship or something. Why do I have to go to law school to get this?
Well, in most countries you don't. It's part of, it's an undergraduate degree in most countries. We elongate the expense. And there's a lot of hooey that passes under that thinking like a lawyer. I think we teach people to think like law professors, or at least that's what we're trying to get them to do. And we seriously neglect a lot of the practical skills that lawyers actually need. But that's a different conversation, unless people want to have it, which I'm happy to have. But I think the expense of legal education is really hard to justify. Given the variegated tasks that lawyers perform. And we'd be a lot better off if we had a model that was closer to the medical profession, in which you have people with differing credentials performing different levels of service. And we had a licensing structure that actually reflected that.
Well, just one more thing, hopefully, on profession and ethics in relation to it, what about the client? That is, you talk about medicine and the importance of the patient and the patient first. There's his history in medicine of being willing to put your own life on the line when people are diseased or in wartime and so on. What about your primary commitment to your client as an attorney? Isn't that different than, again, other arenas where your primary commitment probably is to yourself and to perhaps making as much money as you can, and you maybe let the customer beware and so on, but here is a profession which is supposed to be completely dedicated to the client.
Yeah. Well, one of my favorite New Yorker cartoons pictures a well-heeled lawyer leaning out over his desk and saying to the client on the other side, "And so, Mr. Pritkin, how much justice can you afford?" So we do very well for well-heeled clients with deep pockets, not so good with clients who can't afford it. And what passes for effective representation for, say, indigent criminal defendants who have a right to counsel subsidized by the state is really a disgrace. Lawyers have been said to have provided the constitutional minimum when they were on drugs, asleep, and parking their car during key parts of the prosecution's case. So, I think that certainly we do have an ethic of client loyalty, and it's a mixed blessing. It has produced some overzealous representation for clients who can afford it. I'm thinking cigarette companies, asbestos manufacturers. You pick your some of the lawyers for the Catholic Church, just to throw one more in your direction. And underrepresentation for the vast majority of Americans who can't. And we do some heroic work with legal aid lawyers who work very long hours, oftentimes, for very low pay in an effort to serve. But every major bar association study that's come out has suggested that we can't meet something on the order of 4/5 of the individual legal needs of low-income Americans. That was before some of the major budgetary cutbacks that we've seen of late. And that collective needs, school financing cases, environmental justice cases, those kinds of collective problems aren't even counted in the legal needs study. So that gives you a sense of how far we are from approaching the ideal. So, equal justice under law, that's the slogan we put on courthouse doors, but it by no means describes what goes on inside them.
So part of what we promised you in terms of the flyer on this session is ethical issues unique to the legal profession and ethical challenges in practice in the legal profession. So this is this ethical challenge that we are not serving most of the people who would need attorneys. That's a really radical problem. And what is the possible way of dealing with that? How can we get at that?
Well, one thing is the bar could require lawyers to perform a minimum of public service. We now, and going back to my earlier point about a code drafted by and for lawyers, so we have an aspirational norm of 50 hours per year, which is only an hour a week, but less than half of the profession meets that. Only something like 20% of the lawyers in the wealthiest firms meet it. So we're a very long distance. And the last time I did the figures was something on the order of, if you averaged in everybody who made no contribution, it's something on the order for the profession as a whole for a half an hour a week and 50 cents a day. That's what the profession gives. We could do a lot better. We're one, if not and the figures vary here, but we are either the first or the second highest paid profession in the country. We could certainly afford to do better by requiring service, and law firms could do it. themselves if bar associations were unwilling to do it. That would be a start. It's not a substitute for well-funded legal aid programs where you have specialists who perform these services, but at least it would be make a significant dent in the problem. And I think more importantly, it would also give many more lawyers some sense of what passes for justice among the have-nots. So if they were doing more direct services for those who couldn't afford it, I think you would see a lot more pressure for change in laws and policies around issues that affect those who need legal assistance most and who are currently in the least privileged place to receive it.
Do you think if we looked at medicine as an arena which has changed professionally quite a bit over the last, say, 50 years, where insurance companies and hospitals have a lot more engagement with the profession. It's not just what doctors want to do. And we have government programs like Medicare and Medicaid that have a substantial impact on practice of medicine. If we did that in the law, would we be better off if we had legal insurance of the sort that we have in terms of medical insurance, if we had better government programs and more substantial? You talk about the need for government subsidy of attorneys. Would we do better?
Well, we sure would, but I think the chances of that politically are about zippity-doo-dah. Others may have a different view, but I think it's no accident that did we hear any of that in the last presidential election? Where all the focus was on health care, nothing about underserved individuals with respect to legal needs. And we're certainly not hearing it in this election cycle. So, lawyers, for some of the reasons we mentioned before, are not a beloved group. And I think the notion that you're going to get massive public subsidies, I'm all for them and have been writing about the need for them for decades. But I don't think that's where we're going to make the major improvements. I think the major improvements would come if the profession took much more seriously its own obligation to provide services, and if it gave up some of its monopoly over the provision of routine assistance to people who had 1-year training or 2-year training and who were licensed. And the bar has really fought very much the model that you see in the medical profession, where you have physician's assistants, you have nurses, you have a whole range of individuals with different credentials who can provide certain levels of basic care. We ought to be moving in that direction in law.
So let's go to some of the ethical issues that are unique to the profession, because I think one of the things we'll find through this whole series is that what we talk about as ethics commonly in society is often quite different from what you see in professional codes of ethics that, for example, seem with attorneys to encourage us to be hired guns for whatever cause may come down the pike. And you mentioned cigarette companies, et cetera, et cetera. And this is a principle of access to the legal system that we feel quite strongly about, that people need to be able to have access. And that means when somebody comes to you, regardless of what kind of case they may bring to you, as long as you're not violating the law itself or the ethical obligations of the profession, you need to take that case and you need to provide representation. So that is sometimes counterintuitive for a lot of people, especially where it comes to, say, defending rapists and murderers. How do we fit that into our sense of ethics more generally?
I think it would be counterintuitive to most lawyers, the notion that they had to take whatever walked in the door. That is the rule in some countries. There's what's called the cab rank rule. They're supposed to be like taxi cabs and take any comers. We don't have that. We use the filtering device of money. So, I'm perfectly free to turn down anyone who can't pay my fees. And I think that's, a less adequate filtering device than some kind of moral standard that asks lawyers to take seriously whether they think that this is how they want to use their time and talents. Certainly the right of access to the legal system is a right worth protecting. But unless you're the last lawyer in town, there's no reason why the client deserves your services if it's a cause that you find personally repugnant. So I think a lot of lawyers rationalize taking on some rather unpalatable cases on the ground that every client deserves representation, when in fact that's not how they structure their practice life. The clients who deserve representation for most lawyers are the ones who can afford to pay the fees.
So let's go to the places where there is government subsidy. So if you're talking about criminal defense for the indigent or prosecutors of crime, would you say the same thing, that they should be able to make individual decisions for this particular rapist or this particular murderer, or say they don't want to be engaged in pursuing any issues that have to do, or defending any issues in certain arenas, now that they're government attorneys? Would that make a difference?
Well, I think if you're a public defender, for example, you hold yourself out, it's not your job to pass judgment on guilt or innocence. We reserve that right to, triers of fact. And that's an extremely important constitutional guarantee, the right to effective representation of counsel, regardless of what the lawyer thinks about the merits of the cause. And we want that right even for those who are guilty of the most heinous offenses, because the only way to be sure that you've got guilty people is to test guilt or innocence before neutral fact finders in at least some of the cases. And so we build in a series of protections against prosecutorial abuse and sloppiness by having an effective representation on the other side. And we accept as the price of that some guilty individuals may go free, but the cliche goes, better that than one individual who's actually innocent convicted. So I think it makes sense if you think systemically about what's at stake. In civil context, we don't have the same commitment to ensuring effective representation for every cause. There's no right to civil legal assistance in this country. And there's certainly no right for a cigarette company to have you as their lawyer if you can't defend what the company is in fact doing. So I encourage lawyers to exercise some individual moral accountability in deciding the kind of law they want to practice and the kind of clients they want to take.
But it does become more difficult, doesn't it, as you say, if you're a criminal defense attorney, or maybe, I practiced in legal services, where we have a means test, people come in the door, and if they meet that means test, then we represent them. So does that mean we who are government employed and who are the last resort in many ways can't have the same kind of moral concerns about our clients that a attorney could in private practice?
Well, I think that the morals creep in to some extent when lawyers decide how to spend their time and which cases they go to the mat for. And certainly if you ask any public defender, the thought that they might actually have an innocent client is, exercises a powerful force on their willingness to go to the ends of the earth for that client in ways that they probably wouldn't for a client who's a third or fourth time offender who they're pretty sure ought to just take the plea. And I think the same thing happens in civil cases. Most legal aid lawyers are engaged in triage all the time. They can only take a few of the cases that come before them, and they have to make a judgment that sometimes is affected by what they think of the merits of the case and the urgency of the need. So I think even in those contexts where we're committed to providing assistance, lawyers have some discretion in allocating their caseloads.
So let's take another area of ethical issues unique to attorneys, confidentiality. There's situations where, for example, confidentiality would prevent a lawyer who knows that somebody has been falsely or improperly convicted and imprisoned, may go to their death, a family who is grieving the loss of a loved one and you know where the body is, and so on. What about confidentiality, and how can it be upheld as a moral position in these kinds of circumstances?
Well, the standard argument is that you need, in order to ensure effective representation, a degree of trust and candor on the part of clients, and you can't get that unless you promise them confidentiality. And I think that's true, but it's also the case that the bar has carved out a lot of exceptions that most thinking members of the public, A, believe are already there, or B, if you ask them, believe ought to be there. And there's certainly an argument that more should be there than the ones that the profession now recognizes. So, for example, lawyers have discretion to disclose confidences when necessary to protect imminent life. And, the question is, why should they have the obligation to do that? So if you know, for example, that your client is guilty of a crime that, someone else is about to be sentenced to death for, what's your obligation there?
Let's, in a moment, open this up to your questions and a wider discussion. But let me ask one more question before we do, which is, what about justice? Is the legal system really oriented towards justice? Many of us went into this profession with the idea that we wanted to commit our lives to pursuing justice. And as somebody who went to both a divinity school and a law school at the same institution, running back and forth across the street for 5 years, getting both degrees, I was told when I would raise issues of justice at the Harvard Law School, justice. What we're teaching you is what judges do, how they make decisions. If you want justice, go to the divinity school. And then at the divinity school, we were talking about issues of law and grace or love or other conceptions. And it was often said to us when we talked about justice, well, wait a minute, justice, that's not the primary emphasis. Our emphasis is on love or grace or something else. If you want justice, go to the law school. So who's doing justice? I mean, where do you find justice in society? And are lawyers obligated to think about these larger questions of justice?
There used to be, when I went to law school, graffiti on the restroom walls that said, "We came talking of justice, we left talking of jobs." My hope is that that's not true at Stanford Law School, and it's certainly not true of classes that I teach, which really are all about justice in a more robust sense than procedural justice. That is just, getting whatever it is that spews forth from a court of law operating under rules of law. I think there's a substantive conception of justice that I would hope would be one that informed the conversation in most law school classes. And it certainly ought to be part of the conversation of lawyers in their daily practice. And to the extent that it isn't, I think that's a place where we've failed as a profession.
So I'm going to open us up now for conversation, but before I do, I want to introduce Joan Barry, who has set this whole program up through the Ethics Center here at Stanford. And I know as people came into the room, you were hoping that they would sign that. So I'm going to pass that around so that.
I think we have to use the mics for the questions, so we'll pass them on in a pretty informal way. I'm going to grab some plates because I was told the photographs do not look nice. So you people in the front row look photogenic, will you? Yeah. Could I pass this to somebody while
There's a question up there.
In a clean plate area. Perfect.
Oh, you're so good at your job, Joni.
I was wondering if we could get your opinion on the judicial system that we have where some of our judges are elected, and whether or not you feel that an elected judge, how do I put this, compared to a judge that's appointed, does the political process, do you feel that taints the judicial process more, or does the accountability of someone being elected, do you think that holds, looking at it from both sides, how does that affect the ethical issues that judges face?
Yeah, well, great question. You know, every sort of expert body that's looked at the issue of how judges should be selected thinks that they ought to be nominated by an expert commission that's bipartisan and appointed. And part of that has to do with the fact that you really don't want the people who are there to enforce the rights of, you know, unpopular minorities to be hostage to political pressure. And everything that we know about who contributes to judicial elections suggests that there's a lot of interest group politics going on in those elections, which have become increasingly expensive, as all elections have been. And the problem, the central problem with thinking that elections provide a lot of accountability is how many people are well informed about the views of judges in a judicial election. You know, it's a tiny fraction of the public. So I think we'd be much better off if we had a system that tried to minimize the extent of political influence. The federal system, which is an appointed system, is not perfect by any means either. Somebody once said, how do you become an appellate court judge? And the answer was, no, a senator. So, you know, there's a lot of political payoffs and positioning that's involved in the appointment process now. But I think it's, in an ideal world, and a few states have it, you could construct a system that would be better designed to ensure some high level of qualification without forcing people to pander to current political pressures and giving undue power to the political party that's in charge in that particular state or in Congress at a given moment in time. Other questions?
So this is more specific to, say, the Supreme Court. Some of these cases recently, including Arizona versus the United States last year, and then what they're considering probably this year, a case involving gay marriage. To what extent do you feel like a judge should actually try to address ethical issues at hand in those cases, even if it's not explicitly been addressed at a lower level?
Well, by the time the Supreme Court gets those cases, it will have been addressed at a lower level. And, you know, those cases are winding their way up. If the question is, you know, do I think that judges' political beliefs should affect the outcomes in those cases? Was that the question?
Morally. So, like, take Arizona, for example. They didn't consider in any manner whatsoever, are those laws discriminatory, racist? All they considered was whether they were preempted by the, Immigration Act. So that's
Yeah.
my question. Do you feel like judges have a responsibility
To get to the merits? Yeah. No. You know, if the case isn't ripe, and oftentimes, you know, there's some really good reasons apart from protecting the precedential value of those rules. And it's really hard to explain it to, I think, members of the public who you know, aren't schooled in why you have these technical rules of procedure. But they matter in terms of the overall quality of justice, and you have to enforce them in cases where the courts would like to get to the merits in some instances. There are also plenty of cases, and I saw a good number of them when I was on the Supreme Court, where for a variety of reasons, it turns out that this case is not the right case to make law in this area. There's an old cliche about, you know, hard cases make bad law. So sometimes you will find a court looking for a procedural dodge as a way to avoid addressing an issue because it isn't well framed by the case before them. Sometimes, of course, courts do it because they don't have the votes for the substantive position that they want. But assuming that there's a valid basis for the procedural objection, I think giving judges the discretion to exercise that in appropriate instances makes sense. I also think that there are really strong cases in which you want to look for ways to bend the rules, and the Supreme Court occasionally does that. And just last term, they decided a case, it actually was a pro bono case, in which a lawyer facing a capital sentence was going to be put to death because his court-appointed counsel, working for a fancy New York firm, hadn't adequately dealt with the transition to a different firm. And so when papers came to be mailed to that those lawyers at that law firm, they were just sent back to the clerk as, unopened, recipient, unknown, whereabouts unknown. And so if you'd had a really strict rule that you're accountable for the faults of your lawyer, which is generally the case, you would have said, well, sorry. But that's a kind of context where the Supreme Court, the injustice of that was so overwhelming that the court looked very hard to find a technical reason for finding that that the client deserved a hearing in those circumstances. So I do think that, courts try to make the procedural rules adapt to the substantive merits of the case when they can. A good judge does it more effectively, obviously, than a less skilled judge.
I don't have the mic.
Let's get you the mic. That's important.
Well, they're recording
It's
this,
for recording purposes. yeah.
Okay. So I actually really like the idea of tiers of legal capability and testing, but I'm hesitant to say that the legal profession is alone in being a money-based profession, and I'd like to include actually the medical profession in that. It seems to me that it's a bit more of a societal issue when it comes to a capitalist structure, because even if you look at medicine, say a dentist, I can get a much better dental care if I can pay more for it. And I can get much better medical care if I can pay more for it. If I have a hangnail and I'm willing to pay for the CAT scan right now, I can get it. And it seems like there's also a triage issue in the medical field of ER doctors. So I wonder if it is the legal profession or if it is professions in America that cause this sort of structure of preference to patients based on the amount they can pay.
Well, that's a great question. I don't think it's just the capitalist structure, because you certainly have different strategies for delivering health care in other countries that are capitalist. I mean, if you look at Canada, for example, where you have guaranteed rights of health care. And while it's true that if you have infinite resources, can have that hangnail dealt with at great expense, if you are like the vast majority of Americans dependent on health insurance coverage, that's not going to happen. And insurance companies have provided some kind of counterweight for cost containment. They haven't always done it effectively or efficiently or in ways that we find commendable, but there has been a countervailing force in regulating the medical profession that comes from the government and the insurance companies, because they have a huge stake that runs counter to the medical profession, which oftentimes, just would love to have more reimbursement for more services. There's now a whole move in the delivery of health care to try to get to more cost-effective structures for delivering care and more performance-based measures for compensation. And I think that there's something that we could learn in the legal profession from some of those strategies.
So we've discussed a bit for a lawyer what acceptable ethical conduct looks like, and maybe sort of gestured towards what exemplary ethical conduct looks like. I'm wondering for those who take a legal education and end up in a more academic vein, it seems clear enough what acceptable ethical practice looks like, but I wonder if you could say a bit about what really exemplary ethical practice in legal well, not practice at that point, but discharge of those responsibilities.
Well, I guess I would think that it would be somebody who took very seriously their own moral convictions in deciding how they wanted to spend their time and their talents. And it would be somebody who took seriously the notion that with the professional license comes extraordinary opportunities, but also obligations to give back in a significant way. So to perform some measure of public service, and I would think, 50 hours is a reasonable minimum standard. But the exemplary lawyer would probably be performing a lot more. An hour a week isn't that much when you consider what the routine needs that are unmet in this country now are. So I'd love to see, if we're setting standards for the idealistic attorney, a much higher level of public service than that. And we give awards to the lawyers who do that. We recognize that now in the profession as one of the ultimate criteria for a life well lived in the law.
Is part of your question how, when you're a law professor in a law school, it may differ, sorry?
Or, a researcher or somebody.
Research, how that might differ, if at all,
Oh, I
in
see.
terms of ethics?
Well, I was of the view when I was president of the Association of American Law Schools that law professors, no less than lawyers, had a public service obligation. And, that was a hard sell to my colleagues who took the view that pretty much everything they did was a public service. So, here I am tonight, speaking to you. Am I getting any credit for this in the profession? So, but, I think this is not, while it is a public service of sorts, I think we also have an obligation to give back to the people who are least able to afford it. And I'd like to see us setting a better example for our students than many professors do right now. In terms of other ethical obligations, I think we ought to hold ourselves to higher standards as role models. So in terms of conflicts of interest, disclosure obligations if we take money for doing expert witness work, and then we write a law review article that's based on it, I think that ought to be disclosed. And we haven't done a particularly good job policing ourselves as a part of the profession. I think we could do much better.
So I'm curious, what approaches have you found are most effective for teaching ethics in the classroom? Is that really possible? And I guess, how have you seen the baseline ethics? I don't know if you can quantify that, but how has that changed during your career as a professor with students coming in, if at all?
Well, it's changed a lot. When I went to law school, I had no course in ethics. We were taught it by the so-called pervasive method, and it was so pervasive that I think it eluded all of us. At other schools, it was mentioned in orientation programs, or there would be, a non-graded special supplemental course. In the few places that actually taught it as a requirement, I canvassed a few of the leading law schools. It was regarded as somewhat of a joke, taught to empty seats and empty minds was the slogan. There was a famous professor at Virginia who was known as Ether Lips, and who used to teach the code of conduct in rules of three. So, today we will learn 3 justifications for zealous advocacy. Tomorrow we will learn 3 kinds of conflicts of interest. And he would have snap quizzes to make sure that the students could match up the right rules to the, it was ludicrous. So we've come a long way from that. My own view in terms of teaching legal ethics is the best way to teach it is through experiential learning. So I think either in conjunction with clinical work or in conjunction with a problem method, and because we can't afford the clinical placements. My own class is a problem-oriented class, and they're all real problems taken from real cases and autobiographies and news accounts and so forth. And I think getting students to work through those cases before they have a vested interest in coming out one way or another is a good thing. I also do some bells and whistles. I have some instant voting, so students can, forced to take a position, but they can do it anonymously. And that's always illuminating to see how you would resolve a particular issue. And I do some teaching with media, with documentaries, with popular entertainment, with good films, clips, because I think those bring the issues oftentimes home in a very immediate way that holds resonance for students and, also makes for a lively class discussion. So those are my strategies. Scotty's taught it with literature, which works too.
Yeah, before we're done, I hope we get a little bit of opportunity to look at the bigger issues, I would say, of even if you're very effective as an attorney and you have commendable ethics and you are well engaged in public service and so on, how do you make your life ultimately real? And this comes out of a book that the two of us have worked with, which is The Death of Ivan Ilyich, a Leo Tolstoy novella where an attorney in his mid-40s contracts a terminal illness and begins to ask these larger questions about what's the whole picture of my life, and how have I been in the courtroom. He ends up as a judge and so on. And then what is the relationship of that to my outside life with my friends, with my local community, with my family, and so on. And there was an attorney, a law professor here for 30 years, Harry Rathbun, at the law school, who would suspend his last class of the year to give what was called Harry's last lecture, trying to look at these larger issues of morality and ethics and how to live a fulfilled and meaningful life. And Ivan Ilyich has to ask those questions, and sometimes literature is the best way to get at those kinds of issues.
I was depressed for a week after I read The Death of Ivan Ilyich. My question goes back to the 50 hours of pro bono. Why? No one expects a plumber or a CPA to give 50 hours of pro bono work. Is it something more than just the gilded nature of our profession?
Well, we have a monopoly over an essential service, and I think that distinguishes us from the plumber or from the grocer. I'd be happy to see doctors have that same public service obligation for some of the same reasons. There's urgent unmet need, and they've got a license to perform, a service that is life-sustaining. So I'd be happy to see it generalized somewhat, but I think lawyers stand in a particular position, both because of their relationship to the justice system and because of the value that the license provides for them. It's reasonable to expect them to give back a certain amount.
Yes, I have a question. We talk about the law and the legal profession as a learned profession, in that there's specialized knowledge that lawyers have that the rest of us don't. And I think that kind of influences our relationship with them much as it influences our relationship with doctors. If we're diagnosed with a disease and a doctor tells us that we need to take a certain action, we're kind of at their mercy. We don't have the experience or the knowledge to check that. And with the law, that could seriously affect our lives. If we don't have a full understanding of what our lawyer is telling us, that could seriously affect our justice. We have to trust these lawyers. And my question is, do you think that it's a problem that there's a huge gap in understanding between lawyers and everyone else? And if so, is there something that we should do about it, like require everyone to take law classes as part of their education for citizenship or something like that?
I haven't thought deeply about requiring law classes as a component of citizenship. I'm not sure what they would consist of. I mean, I guess I find it pretty appalling that, most Americans don't know certain basic things, like that there are 3 branches of government, and who their state senator is. So I'm all for more civics education, and if you could build in some basic familiarity with a few constitutional concepts and rights, I'd be all for it. Stanford has a program in street law in which law students go into public schools to try to give kids who are likely to brush up against the law some better understanding of what its requirements are. And I think that's all to the good. So building those kinds of classes into the curriculum, I think is useful. But I think, if I were reforming civics education generally, there are a lot of things that I'd love to see stressed more. And I'm not sure that a lot on the technical rules of law, just in case they need to have a conversation with a lawyer later, would be what I would go for. I think I'd be much more likely to want to see lawyers have to take courses in effective communication and counseling, so that they had some capacity and felt obligation to reduce the comprehension gap.
Good evening. Thank you both for your time tonight. We've talked a lot about the steps that should be taken to restructure the legal profession and the role of lawyers and professors, perhaps, in fulfilling that. What advice do you have for those of us who are about to embark on a legal career, who are currently, pursuing law school or maybe pursuing law school in the near future? What can we do to either be part of that change or steps as individuals to further the cause of promoting ethics in the profession?
I'm so glad you asked that question, because I was going to, seize an opportunity to try to get that in, since I have an audience that's partly pre-law. I think before you go to law school, spend some time in the kind of job you could imagine yourself doing as a lawyer. I see too many law students who end up in law school because it sort of wins by default. They don't know what else to do, and it seems like, gee, it's connected to justice, it's got some intellectual challenge, it makes a decent living, and then it's a rude shock to them to find out what it is that most lawyers do, and that the kind of jobs that they thought they wanted to have don't pay the kind of salaries that they have come to expect as their due. And it's really not a good moment for many of them. Some of them, I think, go on in an occupation that they weren't ideally suited for. And had they been more informed in making the choice going in and more realistic about what their options and aspirations were, they'd be better off. And my own sense, as somebody who went straight lickety-split through, is don't do what I did. Get a good glimpse of what you think you might want to do. It'll give you a much more informed sense of, A, whether this is the right career for you, B, whether that's the right area of the career for you, and C, much more motivation to get the degree, because you can see that at the end, there's a lot of slogging that you end up having to do, and there are hurdles in law school and the bar exam. If you know that there's a goal at the end that you're really committed to, you're likely to be a more successful student, I think, and to feel better about the vast sums that you're plunking down or indebting yourself to return later.
I'm sorry to say that it is 7 o'clock and we're out of time, so I want to thank Professor Rhode very much for what she's done for us this evening, and also what she's done throughout her career, not only in her teaching, but in her passion for justice. And I will thank all of you for coming tonight, and I hope you'll consider continuing in this series on ethics and the professions. And we will try to advertise them widely and encourage you to participate throughout the year as we look at other professions and ask some of these difficult questions as well. So thank you very much.
Thank you all for coming. Woody Allen said 90% of life is showing up, and it matters what you show up for. So we're really grateful that you showed up for this. It speaks well for your future career in legal ethics. Thank you.